Ms. Rourke. As you can see, Lord Sales and Lord Hamblin are joining us remotely, as well as, of course, as Mr. Mendes.
Yes.
If at any point any of the three of you loses contact with us, if the sound goes, for example, do indicate that something is wrong, and we'll adjourn until it's sorted out. Yes, Mr. Rourke.
My Lords, if I may simply take the liberty by way of explaining what that disc is.
Well, it's been explained to us.
Yes, I'm grateful. My hearing, I'm afraid, is extremely bad, and the disc is excellent, but it is not magic.
Yes.
So please forgive me if I ask your Lordship.
That's not a problem at all.
I'm grateful.
I'm sorry.
Lord, that was Miss Deal.
The Miss Deal, I beg your pardon.
I think we got seated the wrong way round.
Stopped over simply because that was not so much housekeeping as just setting up.
Yes.
Miss Deal got here first and took the end spot, so I was happy enough to take the middle.
Of course. Right, Mr. Rourke.
Lord, can I say by way of preliminary, I'm sadly struggling at the moment with a leg ulcer on my left leg. I have a consultant vascular surgeon who would rather I was with him today in Belfast.
Yes.
But I said I'd rather be here.
Yes.
I'm able to stand at the moment.
Well, no, if you'd rather, there's no point putting yourself
I prefer to stand
through.
to start with, but if I need to in the middle of my submission.
We'll entirely understand. All we'll need to do in that event is lower the microphone, I dare say, so that you can
Lord,
be
yes, I assume the camera won't have any difficulty if
No, I wouldn't have thought
drop
so.
down. So at the moment I'm good, but if it starts to get a bit painful, then I will sit down.
Fine.
My Lord, in which case I think we're good to go.
Yes?
My Lord, the starting point, the first appellant says in this case, is to strip it all away, and at heart this is simply a clinical negligence case, and that's how it must be approached. They ended up with a greater degree of complexity both before Mr. Justice Cokeram and then before the Court of Appeal. But it was never argued by the claimant in its opening or closing before Mr. Justice Cokeram, or indeed initially at the Court of Appeal, that this was a case where you could have judgment based only on an admission made of paragraph 23 of the amended statement of claim and paragraph 13 of the amended defence. And we say if that's really what it was, why would the claimant have taken the approach it did to evidence and argument on Bolam? If we're correct on this, then the starting point is Bolam, that Bolam applies, and I will in due course address separately paragraph 23 of the amended statement of claim. If they're trying to argue some sort of admitted absolute duty to ensure a successful outcome, and I do put the emphasis on that, Miss Deal makes the same point in her case, and the lower courts apparently found, relying on paragraph 23, there would be such, and therefore exclude Bolam, despite the fact paragraph 23, as we say in our statement of case, uses words like proper, which must surely mean reasonable. But if they're in some way departing from what Lord Scarman has set out in Maynard, that healthcare professionals must be judged on the range of differences in practice, and of course the Wiltshire case, which Miss Deal cites, where you're looking at the context of the role they play. We agree the totality of the second appellant's statement of case. I don't disagree with a single word in it. And indeed, I adopt and endorse those parts of it which coexist and are consistent with our statement of case and our position. Even where there are parts of Miss Deal's statement of case that don't necessarily apply to us or address our factual position, I still support and adopt it because, of course, what it demonstrates is that these courts fell into serious error. In other words, they made errors not just in respect to the first appellant, but in respect of the second appellant and findings, and therefore these are flawed judgments at both levels. So my plan now is to address matters in the following order. taking the grounds of appeal slightly out of order, but in what I say is a logical order, bearing in mind I've started out by saying this is Bolam case, and if your lordships were to say to me what's my best point, I would say Bolam. It screams out from the judgments of both Mr. Justice Cokeram and the Court of Appeal, and it screams out from the deficiencies in the expert evidence and the fact that neither expert at the time of the report or witness statement was aware of Bolam and therefore couldn't have addressed it. So breaking it down into sections, it would be the following. Firstly, what's the evidence to which the Bolam conclusions could properly be attached? In other words, the standard was assessed and applied. Secondly, what was Mr. Justice Cokeram's approach to Bolam and the evidence? Thirdly, what was the Court of Appeal's approach to Bolam and indeed its acceptance of Mr. Justice Cokeram on the Bolam standard, and what evidence from the experts supported that? So those 3 points are all our ground 4. Next would be not remitting the case when they disagreed with some findings of breach, which is our ground 3. As your lordships are aware, as far as the first appellant was concerned, a number of findings of negligence were reversed by the Court of Appeal, yet the Court of Appeal did not remit the case back, despite the fact those reversals were on findings of fact as well as findings of fault. And we say that wasn't appropriate. They shouldn't have dived in themselves and made their own findings. Next, our ground 5, which is that the judge got it wrong on the no case to answer. And substantially he got it wrong on that because he misinterpreted and misapplied Bolam. So back to the same theme, it's all about Bolam, together with deficiencies in the expert evidence. Then is our ground 2, the actual construction of the admission based on the wording of the pleadings. I'm only going to deal with that briefly because my learned junior, Mr. Boyle, is going to deal with the whole concept of non-delegable duty, which is our ground 1, and vicarious liability. And necessarily, as in our statement of case, he has to address the ground 2 construction in that. And then finally, I will deal with issue estoppel insofar as it's a separate part of ground 2 based on the interlocutory approach. So as I've said, Mr. Boyle will take ground 1, non-delegable duty, and he will link that to the pleadings and the construction of the admission in the context of paragraph 23. With that introduction, can I now dive into those relevant sections and start off by saying we need to look at the evidence of the experts which could have supported the application of Bolam. Now, I don't know which way your lordships would like me to do this. I'm going to hereafter be referring effectively to 3 different documents. I'm going to be referring to the record to look at the reports, witness statements and transcriptive evidence of the 2 experts, but I'm going to be looking at the joint bundle, to be looking at the judgments, although of course they are on the record. It does mean that I'm diving between the 2 as I go.
That's fine, so long as you give us the electronic page reference, we'll follow you. I should say, I've never in my life read so many papers before a hearing. They're very voluminous,
Yeah.
and we've all read them. So we've gone over the evidence as narrated in the judgments and in the parties' written cases
Lord, that's
repeatedly.
helpful. I may then give you the paragraph numbers rather than reading you out what the paragraphs are.
Yes, that'd be helpful.
If you
I
don't
think
mind just
we could
summarising,
probably...
this is where there is evidence of this is where Pitt Miller deals with that, rather than turning it up. But if anyone feels the need to turn it up, I'm very happy to do so.
Fine.
Lord, I agree with you on the volume of documentation, and you ain't seen the half of it. My luggage going to Trinidad and back was more than I've ever carried anywhere in my life, and it got out of control. But it's why I come back to my starting point. At the bottom of it all, this was a simple clinical negligence case, but degrees of complexity got introduced to it that probably shouldn't have been there. My Lord, starting then on my first point, as to what's the evidence of the experts which could possibly support some sort of application of Bolam. In Pitt Miller, it's electronic bundle 460. It's also 479. It's 790, 794, 804, particularly paragraphs 7 to 12. And then as an adjunct to that, I would draw your Lordship's attention to where she uses phrases like the defendants ought to have implemented or would have been wise to do this, or I would hope that they would have done it differently. And those references are 479, 516, and 831. And the relevance of those is that is not the language of Bolam. Hopes, expectations, ought to have done. And another reference would be 837. As far as Dr. Jones-LeConte is concerned, it's at 570, 860, 861, 897 to 898. And we say, if you look at that, that's the totality of the evidence that you could look at to say, is there any standard of care identified? Is there a range of standard of care? Is there a range of practice? And what are the experts saying on that? And the points that I highlight in particular in there are, what did the experts understand about Bolam in approaching their evidence? We deal with this in paragraph 33.3 of our statement of case, but in the transcript you will see it for Pitt Miller at 804, lines 7 to 16, and Jones-LeConte at 871, lines 20 to 25. And summarising it, Pitt Miller says she'd never heard of Bolam before she wrote her report or a witness statement, but she went away by herself and did a bit of reading about it. But we say we don't quite know what she read, but it mustn't have been the correct text, so to speak, because she derived from that Bolam was a gold standard, whereas we know it's a minimum standard. As far as Jones-LeConte was concerned, she said she'd never heard of Bolam, either at the time she wrote her witness statement or the time she wrote a report, or indeed by the time she came into the witness box when I asked her, have you heard of Bolam? And that's in these lines 20 to 25. She asked me to spell it and then said no, she didn't know. Next, if we look at how Mr. Justice Cokeram approached Bolam, he approaches Bolam in paragraph 5 of his judgment, which is on page 1074. He also deals with it further, 1076 and 1077. And then again in 1176, paragraph 5, 1216, 1220, 1243 at 124, and 1244 at 126, and in addition 1141 at 125. But summarising that, in a number of places, both at the outset of his judgment and indeed further in, he sets out Bolam correctly, or he appears to set it out correctly. He cites all the right cases, Hunter and Hanley, Bolitho, Maynard. He runs through the lot and he quotes extensively from the principles. But what he then does is he lets himself fall into error in the application of those principles, in part possibly misled by Dr. Pitt Miller talking about gold standard. And so although he cites the test of the reasonable person, he finds himself wandering into the gold standard, but more particularly accepting what the experts said as to this is the standard required. Well, that's where he goes wrong, because of course Bolam is not about a single standard required. He doesn't look at range of practice, range of responses, or anything of that sort. He simply takes it as if there is one standard only, and that is the standard expounded by the experts, even though the experts have couched their language in the realms of what they would have done, what ought to be done. And of course, we know that the witness statements were in part prepared by lawyers. And my Lord, that's the unusual feature of the Trinidadian jurisdiction in England and Wales, and indeed in Northern Ireland. But I'm not sure about Scotland. Lord Pentland will know. But
I think it would be regarded as a question of weight, a matter for the trial judge, particularly perhaps where there's been very little contest as to the core of the expert evidence.
Well, no, my Lord, I was making the point to explain the unusualness of the procedure in Trinidad, that unlike in England and Wales and Northern Ireland, where the order and direction is to serve an expert's report and that's it, in Trinidad they have a requirement to serve witness statements, and so experts are required to produce witness statements which exhibit and adopt the report. That causes a slight unusualness because the lawyers get involved in the witness statements, the report stands separately as coming from the experts.
But does any of this matter?
Well, my Lord, it could do, because the experts were all but introduced here as witnesses of fact, because they set out witness statements which set out a chronology and ran through and effectively picked up bits of evidence, whereas the reports don't do that, particularly for Jones. My Lord, to put it this way, it's not my best point. I accept that, but I'm simply explaining that the way in which this is done may have led Mr. Justice Cockram into error in looking at how he applied the standard based on what was said. And what then happens is the Court of Appeal accepted, well, there are, of course, I should say, other deficiencies in the expert evidence and as to why they shouldn't rely on it.
Before we move on from this concept of a range of practice,
Yes.
I would like just to take an example and to work that one through. For instance, one of the allegations is that there weren't appropriate supplies of blood available. And the evidence was that you had to have two sets of packed red cells grouped and cross-matched on site for the tub. There was no contrary practice put forward.
No, absolutely, my lord, and that's the one that's accepted. And as was pointed out, we say in our defence we did have them. They were there during the surgery and they were then available post-surgery.
But the evidence about that depended upon the tags, and that evidence was rejected by the trial judge and by the Court of Appeal. Those are concurrent findings of fact. And the trial judge said they weren't available. And that's at page 1143, paragraph
Indeed he did.
127.
We say he got that wrong.
Well, it's a concurrent finding of fact by two lower courts that they weren't available. And he based that upon the proposition that the crisis starts at 3:30 and these weren't available until 4:30. And that at 4:30 the people were still transfusing the wrong product.
Well,
so when you say there's a range of practice, there doesn't seem to be a range of practice in relation to that issue.
not that issue, but there are ranges of practice in respect of what other bloods would be available. Do you rely on a haematologist's opinion? Is it the decision of the surgeon? What is considered to be appropriate? Should it be done within a certain period or out with a certain period? There are a number of other examples where you would have...
Take another one, and that is transfusing O blood, as opposed to transfusing blood matched to this group.
Yes.
And the evidence there is at page 1490, paragraph 252, 1491, paragraph 253, and page 1477, 211. And the evidence is that it doesn't assist. In fact, it's harmful to transfuse O blood in circumstances such as this. Now, where's the range of medical opinion to say, yes, it is possible to do?
There is a range of opinion to say that's an absolute standard, cannot be correct, because the evidence in this...
Where's the evidence of that?
Well, the evidence in this case was that a further haematologist was involved, and Dr. Gutz's progress note, which the judge cites in his judgment, makes clear that the decisions as to what would be transfused were based on the evidence given of the haematologist who was brought in at 5 o'clock, 6 o'clock, etc.
This haematologist didn't give evidence?
No, didn't give evidence, but Dr. Gutz's note must surely be taken as evidence. The judge otherwise treated it as evidence and the records as evidence.
Was there any expert evidence called as to a range of views about transfusing O blood? Or was it even suggested that was a correct thing to do?
Right, there wasn't, but of course the claimant's experts didn't give any range. They spoke as if there was nothing other than one set standard.
Well, if that's their evidence.
Yes, but they couldn't point to, here's a rule, here's a standard, here's something in a textbook, here's whatever. They simply stated it, and not even necessarily...
And therefore there's no range.
Well, one could draw that conclusion.
I mean, you may say there's a range, but where's the expert evidence to support that proposition?
Well, an expert is obliged, when addressing the issue of bolum, to set out...
Why does the expert address bolum at all? Well, I don't understand the basic point you're trying to make. If a witness says this treatment was unacceptable and there's no contrary evidence, is that not the end of the story?
Well, with respect, my lord, the requirements on experts are to set out, for medical experts, that if there is a range of opinions, they must deal with them. If they disagree with them, why they must disagree.
But cases are decided on the evidence led.
Lord, Mr. Boyle would like to pick up this point, if he may.
Well, if you wish your junior to address us on this, then...
Well, he wants to say something. It's easier, instead of him whispering it to me, to say it direct to you.
Well, are you sitting down now?
No. Well, if then we'll deal with it by him telling me, well, he'll deal with it in due course.
Yes, your junior will have an opportunity to address us later.
Yeah. he'll deal with it in due course.
Was there a range of opinion about PT and PTT tests prior to term?
Well,
because the evidence is at page 1478, 215, and 1484, 234.
No, because
we didn't. No range of opinion.
We didn't address any of that because none of that was pleaded against us. The transfusion of O plus blood was not pleaded against us. Doing PT tests wasn't pleaded against us.
Was that evidence objected to in the trial when it was given?
Points were made at various stages where I said this is not pleaded and this is not part of the pleaded case. But yes, I didn't jump up and say you can't say it because I was going to address it in my closing submissions, which I did, and said that the problem had been that the pleadings were drafted before either expert was instructed. The experts, as they admitted, hadn't seen the pleadings when they drafted their reports and their witness statements. They go further than the pleadings do and take up different points. And I addressed the case in closing on the basis of the case that we had come to meet, which was outlined by the judge at the beginning of his judgment, in other words, identifying the statement of issues, together with the points that we say were left in the case. So no, I didn't deal with PTT or PT or range of issues. I didn't commission any expert evidence on that. Those were hematological matters, when there wasn't a hematological case advanced against the first appellant.
Was there any range of opinion about the fact that if you diagnose DIC at 4:45 p.m. to 5 p.m., that within half an hour you should have a proper transfusion, and the transfusion didn't occur until 7:45 p.m.? Was there any range of evidence as to medical opinion about that? That there should be a reaction within a short period of time upon a diagnosis being made?
Well, my lord, there was a dispute on fact in respect of that. But again, the same answer. It was made clear at the outset of the case that the case against the first appellant only went up to 3:30. Because, of course, at first instance, we were not facing non-delegable duty. And we also believed we were not facing vicarious liability because of the interlocutory aspect. So we didn't obtain any evidence, and I didn't.
I'm sorry for interrupting. The answer to that is there wasn't a range of opinion put because it wasn't perceived that the hospital was responsible for that time.
Yes.
Right. Yeah. And that
Lord,
in turn depends on the
things developed, as I said. The case against the appellant, for the purpose of preparation of it and commissioning expert evidence, making decisions as to call it, was no vicarious liability, no question of a non-delegable duty. Therefore, it was a question of the direct involvement of the first appellant by its nursing staff, which was identified by the judge at the outset to extend as far as 3:30 only. Vicarious liability popped up in his judgment with no warning, wasn't addressed in my closing submissions, but was addressed in Mr. Mendy's closing submissions, and so I made a brief reply to it on the day we turned up to do oral submissions. Non-delegable duty didn't feature anywhere. That was a concept of the Court of Appeal, and so therefore the allegations against the first appellant in respect of non-delegable duty and commissioning evidence on PT, PTT, hematological issues, transfusing the wrong blood, all of which we would say are matters for an anaesthetist or indeed a hematologist, simply didn't arise.
So, as far as your client is concerned, you cannot say that they got the Bolam test wrong in relation to those particular issues because you didn't advance any evidence about it, or you didn't establish that there was a range of opinion about it.
Well, my lord, I think I'd put it this way. Unless your lordships uphold the Court of Appeal finding of non-delegable duty, or indeed that vicarious liability is a runner as well, then those issues have no relevance to the first appellant. And so any application of Bolam against the first appellant, other than dealing with those issues, would be wrong. And of course, the judge at first instance was not dealing with non-delegable duty or directly vicarious liability, and so therefore he did misapply. And of course, when we get to the Court of Appeal, findings of negligence against the first appellant disappear, other than those that fall under the umbrella of non-delegable duty, and all the findings of breach at the Court of Appeal are dealt with in that way. So we say that therefore issues such as haematological ones, blood transfusions, etc., only come into play for the first appellant because of the imposition of a non-delegable duty, which was never pleaded, never argued before the Court of until the Court of Appeal. Lords, I'll move on because I'm conscious of my time and wanting to leave Mr. Boyle time to deal with non-delegable duty. We did make a point in our statement of case about the other deficiencies in the expert evidence, breaches of CPR 33, and the changes in evidence, both experts giving the same evidence, same paragraph numbering. We deal with it
before leaving the vicarious liability point, I was just looking at the defence, and the allegation is at page 7, paragraph 11, which is then admitted at page 24, paragraph 4.2. So paragraph 24, 4.2 admits, save that the third named defendant was the servant or agent of the second named defendant, these defendants admit paragraph 11 of the amended statement of claim. And the amended statement of claim seems to allege vicarious liability.
Well, my lord, I'll come to that when I deal with the construction of paragraph 23 and the paragraph 7 admission, if your lordship doesn't mind. But in summary, I'd say this. That's a very inadequate paragraph, paragraph 23, open to misconstruction, because it's
24.2.
23 of the statement.
Oh, no, this is a separate point. The 23 is a non-delegable duty, but paragraph 11, read with paragraph 4.2, seems to be admitting vicarious liability.
It's 4.3, is it?
4.3, is it? Page 24.
Sorry, what are we looking at?
Page 24.
Paragraph 11 reads, if I'm on the right page, the TARP procedure was performed by the second defendant as a surgeon, the third defendant is an anaesthetist, and the servants and or agents of the first defendant as attending medical staff.
Yeah,
that doesn't refer to either the second defendant or the third defendant. They're identified separately. The reference to the servants and agents of the first defendant as attending medical staff is all the others who participated in this event. In other words, the haematologist that came in, the second anaesthetist that came in, the nursing people, the blood bank people. Otherwise, why do you identify separately the second and third defendants? We say that's not an acceptance of vicarious liability. If it was, then why did we lose the preliminary issue in front of the same judge, Mr. Justice Kokaram, when we asked to issue what were effectively third-party proceedings against Dr. Goetz once he'd escaped the noose?
Where do we find paragraph 11?
Paragraph 11 is at page 7.
Page 7.
Page 7 of the electronic bundle.
It's certainly an admission that the anaesthetist is a servant or agent of the surgeon.
Yes.
And then there's a paragraph, page 24.
Well, Lord, that was always our case. The anaesthetist was engaged by the surgeon, not by us. And I think Ms. Deal accepts that point. somewhere in her statement of case says that he was commissioned.
There was no evidence about that. There was no evidence about who engaged who and what the arrangements were.
There was some paper-type evidence because Dr. Goetz wrote a letter asking us to admit his patient, so indicating that it was his patient, his introduction to us, rather than the other way round. In other words, us saying, we've got a patient, will you come and deal with him? My Lord Reid looks puzzled.
Well, I am quizzical. I know a consultant in an NHS hospital might well...
Sorry?
A doctor in an NHS hospital in this country might well refer to the people he treats as his patients, although he may be employed by in the old days, it might have been employed by the hospital.
Trust Board. My Lord, the distinction is the private hospital sphere, and even in this country, private hospitals work on the basis that the hospital grants practicing privileges.
You can tell us the basis on which they operate as a matter of counsel's assertion, but there doesn't seem to have been evidence about the arrangements.
Well, and take your lordships to the revised agreed statements of facts and issues in this case, which is on 1825 of the electronic bundle. And it's paragraph 2. Dr. Goetz was a specialist urologist who treated the deceased previously. 2004, the deceased decided in consultation with Dr. Goetz to undergo a TARP procedure. On 28th of January, Dr. Goetz gave written instructions to the first appellant to admit the deceased so that he, Dr. Goetz, could perform the TARP on the deceased with the second appellant acting as an anaesthetist. And then paragraph 3, the deceased was admitted for the procedure to be performed by Dr. Goetz, the second appellant as his anaesthetist, introduced by Dr. Goetz, carried out an ECG investigation, and then it goes on. So that's one of the agreed facts.
It's a little bit more complicated than that. For instance, in the statement of claim, page 5, paragraph 3, 4, and 5, there's an assertion that the claimant doesn't know what the arrangements are and wants to obtain information and discovery.
That's correct, my Lord, and we then replied to that in defence, saying what the arrangements were. And indeed, there's a letter somewhere in the bundle, I think in the record, where at the time of issuing the writ and the proceedings, the claimant's lawyers wrote to Gulfview Medical, and Gulfview Medical's then solicitor sent a reply saying, I'm told it's 67, they sent a reply saying, we don't employ Dr. Goetz. He's an independent contractor. It's page 67 electronically.
Were any documents disclosed as to how Dr. Goetz ends up in this hospital operating on somebody, and what effort the hospital makes, what arrangements they make with Dr. Goetz, or indeed with the anaesthetist, all of which goes into considerable detail in decided authorities as to delegated authorities. Well, for instance, the Farage case.
Absolutely, my Lord.
Lots of detail about that.
No case of vicarious liability was put against us.
No delegable duties. Was it
non-delegable duty? Non-delegable duty was never pleaded.
Okay.
Your Lordship may say paragraph 23 says that. We say absolutely not.
Right.
And it couldn't do for the reasons set out in our statement of case, in which Mr. Boyle will elaborate in due course. And on the basis that there was, therefore, no case against us, it wasn't the case we came to meet, and certainly not the vicarious liability one. There were documents for the purpose of the third-party proceedings, but they were against Dr. Goetz and went nowhere. Lord, if I go back to the other deficiencies in the expert evidence, we deal with that at paragraphs 34 and 35 of our statement of case. So I'm not going to elaborate on that. It speaks for itself. Then the question is, how did the Court of Appeal treat Bolam and the expert evidence, which is our ground 4? We deal with it in our statement of case at paragraph 38. The Court of Appeal's treatment of it is dealt with in paragraphs 90, 100 and 109 of the judgment, which are references 1438 electronically and 1409 electronically. And we say that the Court of Appeal effectively accepts what Mr. Justice Cochran said, in other words, his view of the experts. It doesn't undertake an analysis to some extent as to whether the standard is applied, but yet they do go on and do that, for example, with respect to the first appellant, because they reverse a number of findings. And they reverse a number of findings by expressly saying no proper standard was set out, and therefore Mr. Justice Cochran fell into error. If I can give your lordships the electronic references to those, it's 1467 at 180, 1469 at 183, where they describe them falling into multiple errors as a result of not applying the right standard. 1469 at 186, where they say there was no application of the standard. 1472. All of those relate only to the first appellant. I'll leave Ms. Deal to deal with those that apply to the second appellant. But what we say is, on the one hand, the Court of Appeal says, well, I accept the judge's position on the experts, which of itself one might say, well, they're entitled to do that because the judge heard the expert, but yet they then dive in and attack the judge's reliance on the experts and on his view and their view of Bolam in order to make findings of negligence, which the Court of Appeal simply don't accept and overturn. And we say there's an inherent contradiction in what they do. If we're right about that, there are material findings of fact which they reverse. We say that as their findings of fact, they should remit the matter for a fresh hearing before a different judge. But instead, what they do is to go on and find some allegations of negligence proved against the first appellant, having led him off the direct ones. They down the first appellant based on non-delegable duty and vicarious liability. If we're right...
Can you explain why you say that if the Court of Appeal reverses a finding of fact made by the trial judge, it ought therefore to remit the matter to the court below for a fresh hearing?
Well, my lord, it's more than a finding of fact. These are mixed findings, because it's a finding of fact, a finding of a standard, in other words, Bolam, and a finding of breach or causative breach. Now, if they're saying that, and in 3 of those they do, 1469, 183, 186 and 1472, they're saying there was no standard applied or the wrong standard was applied, Where then do they get the right standard, or where do they identify the standard that ought to have been applied when they say there was none applied? And so it's not just a question of fact, it's mixed fact, negligence conclusion, including involvement of expert evidence, plus then causation. We say in those circumstances it's not good enough to say, right, we quash all of that, but we can go on and deal with this nonetheless by transferring into vicarious liability and non-delegable duty, where some of the same problems still arise in terms of what is the appropriate standard, because they say none is identified.
Mr. Roop, taking perhaps paragraph 186 of the Court of Appeal's judgment as an example or an illustration of what they did when reversing a finding made by the trial judge. It's electronic bundle 1469 at the foot there. What the Court of Appeal appears to be doing there is to identify a failure on the part of the trial judge to pinpoint the relevant standard of care which had been discussed and set out in the expert evidence. And they put him right on that, effectively.
Well, no.
Now,
they're saying that he failed to identify the relevant standard that had been breached.
In the expert evidence. The relevant standard of care identified by the experts treated not with the length of time, but rather the need for proper monitoring. So it's simply correcting a misunderstanding on the part of the trial judge about the applicable standard of care, which is set out in the only evidence before the court, namely the evidence led from the claimant's experts. This seems to me to be perhaps a fundamental difficulty for you, Mr. Rook, that really both courts had no other material to work with when it came to the standard of care, apart from the evidence of the claimant's experts.
Oh, my Lord, if we take then by example...
How could they have come to a... As long as they've correctly understood the expert evidence, then we know what the standard of care was, because it was explained by these experts.
Well, Lord, at paragraph 190 and 1470, they say there's no evidence of a relevant standard of care to be adopted.
By the nursing staff.
So there are examples of both where they say it hasn't been appropriately applied, but where they also say there wasn't in fact an appropriate standard or relevant practices. Another example is 196. Judge ought to have considered whether the relevant practices described by the experts required that the appellant maintain these supplies, and in particular whether the requirement was to have fresh whole blood, fresh frozen plasma. Going back to the Lord Stephen's questions earlier, the Court of Appeal is actually saying it's wider than just saying there's a duty to have the blood. They're saying you need to look at whether it's required.
These are all points that the Court of Appeal concluded in your favour.
Yes, they did, but they didn't remit.
So are you saying it should have remitted? I mean, I don't understand. Why are you complaining about something that was favourable to you?
Because they then went on and applied Section 39 of the Supreme Court of Judicature Act and substituted some findings of their own, which weren't in fact pleaded findings. And that's where we then go down on non-delegable duty and vicarious liability. In other words, yes, the first defendant, first appellant, gets off on all of these points, but rather than then say your appeal must succeed, and indeed they use that terminology, they actually say, although the first appellant now wins on all these points, that doesn't necessarily mean that they win the case or they win the appeal. and they then go on to substitute findings of their own, saying what evidence there would have been that could have been picked up. And they do that taking in matters that were never put to the first appellant and never were pleaded. Sorry, I'm just trying to find the reference where they say, therefore, sorry, I'm just getting... I did have it highlighted, I'll get it in a minute. Well, perhaps I'll not waste time but come back to it. But effectively, they say that yes, the judge made errors, but that doesn't mean the appeal succeeds, because what is relevant is Section 39 of the Act. This is at 1497. And they go on relying upon that to make findings of fact themselves as against the first appellant, which are 1499, paragraph 278, which were never pleaded against us. In other words, if you look at paragraph 278, A is the PT and PTT tests that Lord Stevens asked me about. That was not pleaded against the first appellant at any point.
The PTT tests, I thought at page 10.
I think it's against...
It's A.
It's not against us, it's against...
The negligence of the first offender, servants and agents failing to ensure that PT and PTT tests as prior to the operation.
I stand corrected.
Yes. And also, this all depends upon whether it's a non-delegable duty of care.
Indeed, my Lord.
If it's non-delegable, it doesn't matter who committed the negligence.
Absolutely, my Lord.
Yeah.
Our defence is strongly, this is not a non-delegable duty of care case. We deal with it extensively in our statement of case. Mr. Boyle will address it.
But a non-delegable duty can arise either at common law or under a statutory provision, or it can be admitted.
Sorry, my Lord, I missed that last sentence.
It can either arise under common law or under statute, or it can be admitted.
Yes, we say it wasn't admitted. Yeah. It didn't arise under a statute in this case, and it doesn't arise at common law if one's applying the Woodland principles of the Supreme Court. Lord, the issue we say is that the approach of the Court of Appeal in general was to review the case, paragraphs 176 to 179, which is 1466 to 1467. And indeed, that's what I was looking for, 176. The judge fell into error in arriving at his findings of negligence. The judge seems to have simply arrived at conclusions of fact based on his assessment of the evidence and concludes negligence. These failures by the judge of themselves, however, are not indicative of the success of these appeals. The question for our determination is whether these and any other failures by the judge led him into error when he concluded negligence on the part of the appellants. And that's where the case then changes and becomes non-delegable duty and vicarious liability. If we're right in our submissions on Bolam, then we come to the point that the judge did fall into errors. The Court of Appeal identified them. They shouldn't have gone on to make their own findings of negligence without looking at whether there was appropriate evidence to do so. And they were wrong to employ Section 39 of the Act. Lords, can I then, time being pressing, turn to paragraph 23 of the amended statement of claim, which is on page 6 of the pleadings of the electronic bundle. Can I highlight the individual pleadings against the three defendants as they were at this stage? And it's page 6, it's paragraph 3, what is said about the first defendant. Paragraph 4, what is said about the second defendant. And paragraph 5, what's said about the third defendant. And the first point to make is that if the first defendant was vicariously liable for the acts or omissions of the other two, there was no need for them to be joined as defendants. And the point would have been made that you are liable for them and they are your servants or agents. But it doesn't say that in paragraph 3 that you're liable. The liability is to make sure that members of the medical profession, including the second and third defendants, are what their situation is. But the second and third defendants are pleaded as individual, separate defendants with separate duties owed. And then paragraph 6, is it 6? Yes. The first defendant was under a duty, and then it's to ensure that staff, visiting consultants and specialists, including the second and third defendants, so identifying them as visiting consultants, plus its own attending nurses, are sufficient in number, properly qualified and reasonably competent. It then deals with provision of proper equipment. It then deals with maintain and have available medical records. And then it goes on at paragraph 7 to say second and third defendants were under duty individually and or collaboratively to use diligence, care, knowledge and caution in administering treatment. So the duties as far as they're concerned is administering treatment. The duties as far as the first defendant are concerned are not the administration of treatment, it's the insurance of people being competent, it's the provision of equipment, and it's the provision of medical records. And then the point is made at paragraph 11, the procedure is performed by the second defendant, third defendant as the anaesthetist, and then any of the servants or agents who were attending medical staff. Well, as I said already, that's different to the second and third defendants. And then one comes to paragraph 23, as amended. Sorry. Page here. It's on electronic bundle, page 9. Further, the defendants, and this is all three defendants, were under a duty. And then the next words we say are important, and we make this point in our statement of case, in performing the TERP procedure. So this relates to the performance of the surgery, not the background provision of staff, not the provision of records, not the provision of equipment, to ensure that during and after the performance of the procedure, any bleeding of the deceased was carefully monitored, properly contained, and so managed, sufficient materials, equipment, and the blood products were available. And then what happens is at paragraph 24, you get specific pleading of negligence against the first defendant, its servants or agents, and it doesn't identify in there the second and third defendant as servants or agents, because we see particulars of negligence against the second defendant on electronic bundle page 12 and against the third defendant on electronic bundle. Well, actually, no, by this time I think it's just the second defendant. So in any event, it's pages 12 and 13. And so what you have is a distinction between the first defendant and the clinical matters. We say, therefore, when you come to the question of admission of that particular paragraph, what is it that is in fact being admitted, bearing in mind that what you have is a defence that belongs to both defendants. And we see that at page 25. I'm sorry, I'm struggling with small numbers. Yeah.
27.
Yeah, sorry, it's 27, isn't it? Yes, it's paragraph 13. Sorry, it's 28. Save that these defendants admit paragraph 23 of the amended statement of case, that they deny paragraph 24. First name defendant specifically denies the particulars of negligence pleaded therein, and then avers that various matters. So what you've got is a bold admission, but an admission of what? Because the allegation at 23 was unparticularised, doesn't say which of the three defendants it's against, and the admission of it doesn't deal with who's admitting it and what's admitting. And of course, as I pointed out, paragraph 23 says in the performance of the TERP procedure, and the first appellant does not perform the TERP procedure, and nowhere is it alleged that the first defendant, first appellant, does perform that. Yet Mr. Justice Cokeram and the Court of Appeal deal with this and these as very crucial points. The Court of Appeal at 1448, Mr. Justice Cokeram at 1101. We say they fall into error in doing this, that they take too simplistic approach. If it was a non-delegable duty which was effectively being admitted, it should have been pleaded as a non-delegable duty. Nobody argued it as a non-delegable duty before Mr. Justice Cokeram. The highest that Mr. Mendes put it before Mr. Justice Cokeram was, well, you've admitted this, so there's no more to it. But as I said at the outset, if that was the case, why did the case proceed on individual particulars of negligence and calling of expert evidence? Because they would have said, here's a duty which is an absolute duty to guarantee outcome.
But you still have to, if it's a delegable, non-delegable duty, you've got to establish that someone who was negligent. And you've still got to call expert evidence and apply the Bolam test. It's just, you have a duty, you cannot delegate it.
Yes.
The duty is to take
Lord, I
reasonable
understand
care.
that, but that's not how the case was put at first instance. It was put as, you've admitted this, full stop, and therefore you're down because of that. The words non-delegable duty never featured in the submissions before Mr. Justice Cokeram or in his 93-page judgment. This was not a non-delegable duty case. It became a non-delegable duty case in the Court of Appeal as a result of the individual failings of negligence against the first appellant falling away. And we say it wrongly became a non-delegable duty case because the 5 Woodland tests weren't made out. There was no statutory imposition of a non-delegable duty. And if it's coming by way of an admission, that paragraph 13 of the amended defence wouldn't be said to be a sufficient admission of a non-delegable duty because paragraph 23 doesn't clearly plead a non-delegable duty.
I haven't found all the references, but there's certainly one reference at 1119, paragraph 88, to the judge of first instance saying it's a non-delegable duty of care. He does that not on the basis of the pleadings at that paragraph, but on the basis of the evidence and the lack of evidence as to the relationship between Gulfview and Mr. Roopchand. So I hesitate to say that the judge does refer to a non-delegable duty. I'm not certain that I found all the references to them, but there it is in black and white.
Well, Lord, it was never argued in front of him, and insofar as he does say that, he then gets himself in a mess because he also finds vicarious liability, and you can't have both. You only introduce a non-delegable duty if you haven't got vicarious liability.
I don't know why you can't have vicarious liability as well as non-delegable duty. You can be liable in both ways.
Well, my Lord, if you're looking at it at common law and Lord Sumption in Woodland, the reason that you impose a non-delegable duty is the need for fair, just and reasonable in circumstances where otherwise a claimant would be left with no remedy because there isn't a relationship between the claimant and somebody else, and there isn't vicarious liability of the local authority or whatever it may be for the actual tortfeasor. That's when non-delegable duty comes into play in order to give a remedy to the claimant. But if in fact there's a vicarious liability in a direct employment relationship, then there's no need for a non-delegable duty. The case is one and vicarious liability should be pleaded as such and dealt with as such. But the difficulty here for the judge is that at an interlocutory stage, the same judge had denied the vicarious liability point and had said we were concurrent tortfeasors and consecutive tortfeasors, and therefore we weren't jointly liable for the same damage. Well, Lord, if I can turn to where we deal with this in our statement of case, and it's paragraph 19 of our statement of case, because I think we set it out.
I hesitate to say it, but wasn't one of the grounds of appeal to the Court of Appeal that the trial judge erred in misapplying the principles as to non-delegable duties of care, which presupposes that he was applying a non-delegable duty of care?
Lord, if I can take you to 2033, which is our statement of case dealing with paragraph 23. We say what the paragraph does not do is assert that the first appellant owed duties in respect of the performance of surgery, nor does it assert that the second defendant or second appellant were servants or agents for whom there was vicarious liability. There's an incompatibility between the allegation that the first appellant might be vicariously liable, that it was liable to exercise in the working relationship, with the allegation in paragraph 6 requiring the first appellant to ensure the second defendant and the second appellant were properly qualified and reasonably competent. And then we deal with, in paragraph 20, paragraph 7 identifies the duties imposed on the second defendant, second appellant, but not the first appellant, in administering treatment to persons under their care. And we say we're not, of course, administering treatment. We're providing services, equipment, records, etc. And then turning to 2035 in our statement, we say there's a more fundamental point on pleading, and that is what is being alleged and admitted. Defendants were on a duty in performing the TERP procedure to ensure duties asserted and admitted arise only to the extent we're performing the TERP procedure. And going back to my Lord Stevens saying you still would need Bolam and negligence, this is pleaded as a duty to ensure, in other words, ensure an outcome. It's not pleaded as a reasonable, responsible or proper duty, and it applies to those who are performing the TERP procedure. And because the first appellant didn't perform it, we say there's a tension in what our paragraph 27, the respondent in the skeleton argument for the Court of Appeal, actually says the judge found on the pleadings that the parties played distinct roles in respect of the TERP procedure, interplay in the roles, with the first defendant being responsible for the nursing staff and the two specialists for the surgical procedure, and that they were not joint tortfeasors. And yet, the Court of Appeal and the trial judge said the admission at paragraph 23 was not only binding, but placed the first appellant and second appellant under identical duties of which they were both in breach. No assertion of non-delegable duty on the face of it cannot be a direct duty imposed on a party in respect of a procedure who is not involved in the procedure, unless, of course, it is a non-delegable duty. My Lord, I'm not going to stray any further into non-delegable duty because Mr. Boyle is going to deal with that.
I'm just looking, sorry Ms. O'Rourke, the fault is no doubt mine. I'm perhaps less familiar than some of my colleagues with the style of pleading here, but I note that paragraph 23 of the amended statement of claim firstly extends to what happened after the TERP had been carried out, for the whole of the period of the deceased's care following the surgery, and then repeatedly uses language which seems to me on its face to be speaking of a duty to take reasonable care. It refers to careful monitoring, properly containing the bleeding, having sufficient materials, carefully managing transfusions so as to minimize risk. I mean, is that all not eloquent of a duty of care alleged to be incumbent on each of the defendants?
Well, my Lord, yes, if there's a non-delegable duty for the first appellant, then that is properly pleaded and would have to be considered in negligence. And as my Lord Stevens has said, then you'd have to apply negligence in Bolam. But what we say is that it's all prefaced by in carrying out or in performing the TERP procedure. We don't perform the TERP procedure. So because this is a global allegation against 3 defendants, you have to break it down. It would be very strange indeed, and I think Ms. Deal makes this point, that you would have liability for the same outcome and the same issues of negligence against parties who've got very different roles. In other words, the hospital on one side and a clinician on the other. It would be a very strange outcome that one would say that they're under the same duties because it's recognised that the duties are those of the role that you occupy, and that's the Court of Appeal in Wiltshire. And so we say that it's clearly a bad pleading by not differentiating the 3 defendants in that paragraph.
Well, if it's unsatisfactory pleading, Ms. O'Rourke, or unclear in some respect with regard to the division of responsibility. Why is it admitted in bald terms, as you put it?
Lord, it should never have been admitted.
It should never have been admitted. That was a mistake. So how can we put that right?
Well, my Lord, you don't need to put it right in that sense, because we say it doesn't bear the meaning that the judge in the Court of Appeal gave it. But it should never have been admitted because it was an unparticularised allegation. The attorneys acting at the time not only admitted it, but admitted it without differentiating which defendant it was admitted for, when they represented two who were arguably in conflict one with the other.
But isn't the claimant entitled in formulating and presenting its case to simply rely upon the pleadings as providing the framework for the litigation?
Well, Lord, it's not tight developed, because what came next was a list of issues to be tried, and indeed the judge sets them out in his judgment, and one of those issues is not paragraph 23, non-delegable duty or vicarious liability. The agreed list of issues, which came from the claimant, breaks down individual allegations of negligence against D1, D2 and D3, and the judge reads those into the commencement of his judgment. And so the case that came to be fought included that. Your Lordships may well have seen, dependent on your reading, that when I became involved in the case, I said, this is unfortunate, and sought to apply to re-amend the defence. Firstly, to separate out the two defendants and have D1 have its own defence standing there, and two, to address any points such as what somebody might misinterpret paragraph 23 to say. But again, as the judge makes clear in his judgment, I was warned off that on the basis of we were too long out of time to do it. And Mr. Justice Cochran was known as the judge in Trinidad who was a stickler for the rules and the timetables and the procedures, and so I simply wasn't going to get anywhere. I was going to waste court time. So the reality is one's left with inadequate pleadings, we say, on both sides, because the claimant's pleading is confused. Why, if you've got paragraph 23, do you need the rest of it? And why do you plead individually then against D1 and D2 and D3? And how do you reconcile identical duties being owed by people who have different responsibilities? Lord, I think my only other point is that I was wishing to address at this stage, because I'll address Mr. Mendy's response when it is the appropriate time for me to do so. It's a question of issue estoppel. That this same judge said at the very outset of the trial, once again, having already said it at the interlocutory stage, that these were not joint tortfeasors. And yet, when he comes to his ultimate conclusion, he appears to say we're vicariously liable for D2, second appellant, but also Dr. Goetz. Surely there is an issue estoppel in those circumstances. The Court of Appeals say, well, I could have ignored him and ploughed on, or in essence they say, I could have ignored him and ploughed on in any event to adduce evidence to show that we were not vicariously liable, and I could have contested that issue. Well, there wasn't an issue for me to contest because it wasn't on the pleadings, it wasn't on the list of issues at the outset of the case, and it had been dealt with at the interlocutory stage. So what would I have been doing in our limited time clock trial, where I was under a time clock in respect of evidence, etc., to be calling evidence or making points which were neither here nor there in the outcome, because nobody was asserting them against me? And so the Court of Appeals finding that it was permissible for him to do that volte-face because he now had further evidence and he could look at it. There was no further or greater evidence available to him at that stage. Indeed, he makes much of the point there was no evidence as to the arrangements. Well, the burden would be on the claimant to produce evidence of the arrangements. If the claimant is asserting vicarious liability, then the claimant should adduce the evidence.
I see that at page 2039, paragraph 30, it's asserted on behalf of the appellant, just before paragraph 31, that this is both unreasonable and wrong in law. But no authorities are quoted for it being wrong in law. And there's a footnote to the respondent's case, which I think is at page 2100, which sets out what the legal principles are.
Yes.
And I was wondering whether or not what the authority is that you wish to advance for it being wrong in law, and how you join issue then with the respondent's proposition. I'll just find the reference to the. Just give me a moment.
Well, yes, we don't cite.
Electronic 2100.
Yes, 2100.
And there's a footnote 2.
Yes, we don't set out a particular authority.
You just say it's just wrong.
Yes.
Okay.
But what Spencer Bar is dealing with is not barring a further application, although it's not likely to succeed unless supported by additional evidence of a different argument. So in other words, it's saying I wouldn't have been barred from making another interlocutory application, but it then identifies I wouldn't have won, and your lordships may or may not know, I'm not sure if it's clear from the chronology, after we lost in front of Mr. Justice Cochran, we did issue contribution proceedings against Dr. Goetz, and those were thrown out as an abusive process on the basis that we'd already had the issue decided in the interlocutory proceedings, and so how could we go again? So it takes the point of Spencer Bar not likely to succeed. It's not just that, it could indeed be construed as it was, as an abusive process. And so for me to try and introduce it in any event in front of the judge when I'd no knowledge that it was going to take that turn and that he would do a volte-face, I wasn't psychic, I couldn't see that that was going to come. He had made it clear at the outset when discussing the issues that he took the view that they were concurrent tortfeasors and not joint tortfeasors, and there was no indication that he was going to change his mind. Lord, I'm going to check. I think those are the points that I wish to make, but I'm just seeing that nobody around me is telling me there's anything else I should address at this time. Lord, in which case, Mr. Boyle is going to follow on and deal with non-delegable duty, and he may well sweep up one or 2 points that I've probably got wrong and that he knows better.
Thank you, Mr. Rourke. Mr. Boyle?
My Lord, can I first of all deal with your Lordship's comments on the range of opinion on the Bolam test and whether or not the medical evidence put forward by the respondent was sufficient? What we would respectfully submit is this, that Bolam is about looking at the different possible outcomes and the different possible ways in which doctors in any given circumstance might react. And the question then is not how this doctor disagrees with that doctor, but the question of what a reasonable body of doctors or no reasonable body of doctors would do. And in those circumstances, my lords, we would submit that the starting point has to be a setting out of the full range of opinion as to what doctors can do in those circumstances. do we do A, do we do B, do we do C? And if 60% of doctors do A, and 30% of doctors do B, but 10% might do C, then the fact that somebody falls into category B does not mean that they are wrong for the purposes of Bolan, unless, with the Belitho slant on it, B has now been set aside and everybody is now doing A or C. And what we say is this: if, in those circumstances, the burden being on the claimant to prove the breach of duty, there is no attempt by the experts to set out A, B, or C, and set out what reasonable groups would do. If all they ever do is say, I would do this, and that becomes an ipse dixit.
Well, I'm not saying just I would do this. They're saying what was done was unacceptable, or what was done failed to meet proper standards.
Well, my Lord, we respectfully, what is said is this falls down not because no reasonable doctor would have done it, but because if you'd done something else, you would have got a different outcome. And the difficulty is that when you have those experts who are oblivious to the Bolan test and how it then...
Why on earth should doctors be expected to be expert in medical law? It's absurd to criticise an expert witness because they're not expert in the relevant legal principles.
But, my Lord, if one is giving evidence in a clinical negligence case, one sees a liability report as opposed to a condition and prognosis report. There's a differentiation between those two reports. And one sees, as a matter of course, in clinical negligence cases, reports that say the range of opinion is this was done, and actually that's within the range. It wasn't optimal because somebody else would have done something different. It wasn't optimal, but it wasn't negligent. And you can have a suboptimal act or omission that does not render it negligent under the Bolan test.
Are these not very theoretical criticisms which you're making, Mr. Boyle, of the experts who actually testified here? They're theoretical because no contrary material concerning another possible acceptable treatment was put in play.
But
it's a formulaic critique which you're advancing.
Well, it is a conceptual critique because the difficulty, my Lord, is
that's
this.
The problem with it, Mr. Boyle, I think, perhaps, that it's conceptual, but what we're dealing with is what were the real issues actually in play at the trial. And we had eminent experts testify about what they considered to be, just picking up some of the wording which I noted in the evidence, unacceptable, unwarranted, unnecessary, failure to comply with standard medical practice. None of that challenged or contested on its merits at all.
Well, the wider difficulty, more difficult point is this. We have in this case a situation, a particular factual situation, that on a day-to-day basis in courts across the country doesn't arise simply because a defendant has never permitted its own evidence. The difficulty is this: if the expert does not comply with Part 33 as it is in this jurisdiction, 35 in our jurisdiction, does not set out the full range of opinion and then identifies its position within that range, how then is a defendant who is not necessarily going to be even permitted its own evidence, how then is the defendant to challenge it? And yes, it is a conceptual position, my Lord, because Part 35 as now applies, and Part 33 in this jurisdiction, requires that range of opinion to be set out for this very reason, so that it avoids the need for the defendant to say, well, hold on, you have not put forward the correct range of opinion, you've not put forward the full range of opinion. And it effectively puts on the defendant a burden of evidencing where the claimant's expert goes wrong. And what we say is, if the report is so very flawed, because it doesn't address those fundamentals, how then is it defendant to respond? Is it to remedy those flaws in the claimant's evidence, or is it to say, but your evidence doesn't do what it's supposed to do?
I don't really, speaking for myself entirely as a provisional view, see the difficulty with respect to Mr. Baum. The defendant's experts are asked to consider the reports submitted on behalf of the claimants by their experts and to address whether or not there is an alternative acceptable standard of practice different from that which has been set out and identified by the claimant's experts. And if there is, then that becomes a real issue in the trial. But none of that happened here.
Well, that presupposes, obviously, in this case, the opportunity for a defendant to gain its own evidence. But in the circumstances where a defendant would not be permitted to go and gain its own evidence, that then creates a colossal difficulty, does it not? If one is talking about low level, and not this case, but on a conceptual basis, because that is the basis upon which I address your Lordship, on a conceptual basis, there are cases, the majority of cases, where defendants are not permitted their own expert. They're not allowed to go off and get their own expert as a matter of course. So then we have a difficulty that if the claimant's expert, selected by a claimant, chooses not to deal with the issue, and I repeat what my learned friend said, the situation where the witness statements are created in circumstances where they're working with the lawyers, it's admitted that they work with the lawyers in the formulation of those witness statements. It may well be that on the day that the expert is approached by the claimant and asked to produce a report, they do not know about Bolan, but by the time they have completed their witness evidence, they have had the opportunity to confer with the lawyers who know exactly what the test is, and they know exactly what has to be proven, and they know exactly what should be in the report, but choose not to put it in. Now, if that's the case, my lord, is it not the situation where a defendant is entitled to say, you have failed to come up to proof. You failed to prove what you need to prove. What you needed to prove was that there isn't a single sensible group of medics who would act in the way that you did in all the circumstances that prevailed at that point in time in the case.
But it appears to me that you're aligning the practice in Trinidad and Tobago with the rules here. And the rules here, as I understand them, permit the defendant to ask questions of the expert. So the expert puts in his report, and if the expert hasn't dealt with the range of opinions, the questions can be asked of that expert. And they could be asked in such a way that, would you kindly look at this medical journal? It contains a responsible body of medical opinion. Do you agree it does? And get their response to it. But in any event, it doesn't apply to Trinidad and Tobago.
The difficulty, my lord, is that obviously under Part 35, the questions can only ever be asked for clarification unless one seeks the permission of the court, and one would still need to get a relevant doctor to opine and to proffer the evidence against it. But I take your lordship's point is that we are within Tobago and not within Part 33 and not Part 35. But I dealt with it, my lord, because of my Lord Reed's question of Miss O'Rourke QC, and I don't doubt that Miss Steele will be able to address it if there are any other issues that she wants to put. But I wanted to flesh out that issue, my lord, because I could see the difficulty that your lordship had with the wording of the medical evidence and whether or not it sufficed to prove what we say it could never do. Well, can I turn to the non-delegable duty issue? And my lord from Ms. O'Rourke QC has already dealt with some of the points that I wish to cover. What we say is this: we would invite the board to find that the Court of Appeal fell into error and to take a de novo view of the non-delegable duty and the Woodland test. With that in mind, my Lord, I would take, of course, your Lordships to the decision and particularly judgment of Lord Sumption in Woodland. And, my Lord, we're in it starts off, my Lord, at 2911 of the full record. My Lords, I respectfully would take the reference the paragraphs within Woodland. We start off with the fact that the non-delegable duty is ultimately an exceptional scenario that is being identified. If I take your Lordships to 2945 and the start of Lord Sumption's judgment, paragraph 3 on 2946.
Just while we're going with this, is this to establish that if you ignore the pleadings and are looking simply at the common law, you wouldn't expect a hospital to owe a non-delegable duty to a patient being treated in the hospital? Is that where we are?
In these particular circumstances, my Lord, because there is a difference, of course, we say that in these particular circumstances, the evidence, the documentary evidence was there to afford the prima facie conclusion that Dr. Gertz was, in effect, the gateway to Mr. Tesheira's admission on the day in question to the medical centre.
Yeah.
And so what we say is that the imposition, whether on the pleadings or at common law, of a non-delegable duty in these particular circumstances.
Well, the position on the pleadings is different. I mean, if a non-delegable duty is pleaded and admitted, then that's the end of the issue.
My Lord, yes. No, I was going to deal with both the non-delegable duty point in isolation and then deal with the admission point. But I'm quite happy to deal with it the other way around. But it struck me that one starts with whether or not there should be or could be, and then whether the admission overrides it.
Very well.
My Lords, what I say in respect of the non-delegable duty point is that when one looks at paragraphs 3 and 4 and 5, and particularly the 6 and 7 of Lord Sumption's...
My understanding is that the common law concept requires delegation, so that if, in fact, the patient delegates a particular activity to a surgeon, then how can it be that the hospital is liable for non-delegable duty? That, though, depends upon an exact analysis of the arrangements between the hospital and the surgeon. And an example of that is the recent decision of the Court of Appeal in Hughes against Rattan, in which there was considerable evidence as to the exact relationship and the terms of that relationship. There was no discovery of any of this, no discovery of how the anaesthetist ends up in this hospital, or how the surgeon ends up in this hospital, or what the payment arrangements are, or whether the hospital has authority to discharge the surgeon who has ultimate control. All these factors went by the board.
But we say that's the difficulty, because what in fact has happened here is that there has been an assumption, a presumption by the Court of Appeal and by the judge at first instance that there is only effectively one role that this hospital can hold, and that is the provision of activities, activity services, if you like, rather than premises services. And what was pleaded against the hospital in the first instance was that we are a private hospital that do two things. We offer services, medical services to members of the public, and we provide a facility for surgeons in which to operate. And
was there any discovery of any of the documents in relation to that second proposition?
Well, it was identified in the first instance in the letter of response to which Ms O'Rourke has already taken you at page 67. It was identified by Dr. Gertz on paragraph 33 of his defence that he from time to time used the facilities of Gulfview Medical Centre. It was conceded by Dr. Pitts-Miller in cross-examination that she herself had been known to use other people's facilities on a private basis. And it was, we knew that the relationship that Mr. Tesheira had with Dr. Gertz had pre-existed. It went back to 2000, and there had come a point in time where Dr. Gertz had suggested that Mr. Tesheira undergo the TURP procedure. Now, those are evidential scintillae, but they are nevertheless there as part of the documentation in this case. Now, that in my submission does not allow, as in fact happened, the Court of Appeal to sweep aside that evidence and presume a non-delegable duty, which is what they chose in fact to do.
Was Dr. Pitt-Miller in a position to make any contribution on this question about the arrangements between the hospital and the medical personnel? It was just it was really speculation on her part or her own experience in other contexts. So that doesn't help, does it?
Well, my Lord, I understand Dr. Pitt-Miller, I have to look at the reference, but Dr. Pitt-Miller considered that she herself had used Gulfview in that context on one occasion previously. So she was in a position to identify that Gulfview as a centre operated in a facilities, in a premises way rather than an activity way. So she had that direct experience.
Well, perhaps you could give us that reference at some convenient point.
I will, if that will assist. So what we say is, what then happens is that the Court of Appeal simply say there is no evidence here that we can rely upon in support of that assertion that one is simply providing premises. And therefore, we presume that there is a non-delegable duty. And the difficulty with that is, and it comes back to the point which is described in the Appellant's statement of cases as the preliminary issue about paragraph 3 of the Court of Appeal's judgment, that what they do is they forget about the provision of a facility, and they forget about the provision of premises as one of the tasks which the medical centre undertake. And they simply set out that we are a private hospital that offers treatment to the public. And by effectively dismissing that second option and second scenario, we then get into a situation where there is a presumption of a non-delegable duty, which we know from Lord Sumption in Woodland is something that should be exceptional. So what we say is, when one looks at the analysis in Woodland, the non-delegable duty comes to the fore to resolve the problems that would otherwise arise by dint of independent contractors performing those tasks. And if we look at those 5 tasks that are set out at 2957 of the electronic bundle, at paragraph 23 of the decision in Woodland, the claimant's a patient or for some other reason dependent on the protection of the defendant against the risk of injury. There's an antecedent relationship between the claimant and the defendant. We say in both of these cases, actually the antecedent is with Dr. Gertz and not with Gulfview.
In paragraph, Lord Sumption has earlier in the judgment distinguished 2 broad categories of case where non-delegable duties have been held to arise. And the first is a sort of random, well, not, perhaps random isn't quite the right word, but a miscellaneous group of cases. And the second is a particular group of cases which he describes in greater detail in paragraph 23. but it's not, the gist of the judgment isn't that paragraph 23 is an exhaustive account of the circumstances where a non-delegable duty will arise, and you'll know that Lady Hale, in the same case, made it clear that this wasn't to be treated as an exhaustive formulation, and this court said the same more recently in Arms and Nottingham.
Well, yes, but the circumstances that are set out in Woodland, we have these extra hazardous operations, and it is paragraph 6 on page 2947 of the bundle, Lord, which is the first broad category that Lord Sumption references. And the suggestion that there's probably a special public policy where these operations involve exceptional danger to the public. The second category of non-delegable duty is the one that's directly on point in Woodland. And we say that, in effect, that is the non-delegable duty that might arise in the circumstances of this case. The difficulty, Lord, is this, that what in fact is done without thinking by the Court of Appeal, and indeed by the learned judge at first instance, is in effect to assert that there is only one possible defendant upon which such a non-delegable duty can be imposed, and that is the medical centre, rather than the other individual defendants. It brings us into paragraph 23 and how the pleading is actually to be construed as a separate entity. But what I say before going there is, if one looks at paragraph 7 of Woodland and the second category of non-delegable duty analysed by Lord Sumption in those circumstances, in other words, the duty is by virtue of the relationship personal to the defendant, the third section of that categorisation. So the duty is personal to the defendant, but it then delegates it to somebody else. It cannot escape that duty by that delegation. And we say that that is a legitimate formulation, potentially, in cases where the assumption is always on, the assumption of duty is always on the first port of call, the gateway, the hospital or the surgeon. But by analogy, my lords, one could look at the simple scenario of going to a hairdresser's for a haircut and a colour, and the colourist is performing a different duty and from the person cutting the hair. Is the hairdresser, is the salon liable for the colourist? And it makes a difference, my lord, in those circumstances, whether the customer has gone to the salon or is following the colourist from a previous locale. But what we say is the relationship personal to the defendant? Is the duty here on Gulf View to, for instance, stem the bleeding? Or is that a duty on the surgeon? Because if one goes to a surgeon and one asks the surgeon to perform the surgery and the bleeding is not then abated, is it in those circumstances just and proportionate to use Lord Sumption's analysis to blame the hospital for that failure? It was not a personal duty in the first instance, and therefore should there be an overriding and overwhelming non-delegable duty upon the hospital in those circumstances? And that, we say, is the difficulty on the factual basis of this case, because it lies with the claimant, subject to the admissions point to which I'll return. It lies on the claimant to prove those facts of provender. In those circumstances, my lord, what we then have is the analysis from the five-stage test, we say, at 2957 in para 23 of Woodland. Number one is a claimant a patient or dependent on the protection of the defendant. Two, is there an antecedent relationship between the claimant and the defendant, independent of the negligent act or omission thereof, which places the claimant in the actual custody, charge or care of the defendant. Not And in this case, we're talking about, in my submission, the surgeon, and from which it is possible to impute to the defendant the assumption of a positive duty to protect the claimant from harm, and not just a duty to refrain from conduct which will forcibly damage the claimant.
You know that Lord Sumption gave private hospitals as an example of a situation where a non-delegable duty would arise.
My Lord, yes. But in the circumstances that one goes to the private hospital and the antecedent relationship is with the hospital, not in circumstances where the antecedent relationship is with the surgeon.
Well, how long do you have to have an antecedent relationship in order for it to qualify? I mean, this gentleman books himself into a hospital and he has a relationship with the hospital, and it is before the operation that is performed.
But Dr. Gertz books him into the hospital because he's got the arrangement with Dr. Gertz.
But is there a single document from the hospital establishing what the arrangements were?
Well, the evidence comes from Dr. Gertz's assertions on the face of his defence in the first instance.
Well, I mean, it would just surprise me if you can get yourself into a private medical hospital without the hospital making some inquiries about who's going to pay and how the payment terms are going to be carried out and what arrangements are going to be made. I mean, they frequently rely upon insurance policies or employers paying or whatever. And there's a whole process that's gone through about which there's absolutely no evidence whatsoever.
Well, the difficulty that arises is where does the burden in those circumstances lie? And the difficulty that the risk and the trap that one potentially falls into is to look at the circumstances that arise within the United Kingdom, where we have our own understanding about how a private hospital might work, and the facts on the ground in Trinidad and Tobago, where the evidence comes from Dr. Pitt Miller, that in her experience, that's precisely what happens, that you can actually have a patient who has a surgeon who says, if we're going to do this on Monday, then we go to this medical centre and we use their facilities. And we say that that's precisely the circumstance that arises here, that the antecedent relationship is with Dr. Gertz. Dr. Gertz had booked the claimant in for the previous attempt at procedure back in February. Dr. Gertz was the gateway to all of this.
An antecedent relationship was between the deceased and Dr. Gertz, but there could have been circumstances in which more than one antecedent relationship arose. We just don't know, Mr. Ball. That's the difficulty.
We don't. But what we then have, Lord, is the danger that we have the Court of Appeal in this case presuming that we have that there is an arrangement, an antecedent relationship between the claimant and the hospital, presuming that there is a non-delegable duty, and presuming that that which is exceptional can be presumed in the absence of evidence to the contrary, even though there are these, and I accept, relatively modest pieces of evidence that have not been fully developed and do not, in fact, come to fruition because of the circumstances of the case. But nevertheless, in circumstances where we talk in other contexts within the statements of case about a scintilla being sufficient, absent
these questions of fact and the relationship and the payment arrangements and the availability of insurance, etc., these were matters very much within the knowledge of your clients. So why not explain them in the evidence if it's important? And in the absence of explanation, is it not quite understandable, really, that the courts below have looked to the pleadings to see what appears on the face of the language used in the pleadings to be pretty clear?
It wasn't an issue at the outset of the case.
As Mr. Rook says, it wasn't an issue at the outset of the case, but if one actually looks at the way in which...
Well, you say that, Mr. Ball, but whether it's an issue or not turns on a construction of the pleadings.
Well, my Lord, can I, in those circumstances...
And I think both the trial judge and the Court of Appeal have really come to the view that, for whatever reason, the the first defendants have misconstrued the pleadings. And it's now accepted on behalf of these appellants that an admission was made which ought not to have been made.
Well, the admission that is made is one that, with hindsight, would have been made in different terms, certainly. It's accepted, however, by the respondent at paragraph 90 of their statement of case at 2121, that there is here scope for an argument about the construction of paragraph 23 of the amended statement of case. And as is rightly put by my own friend Mr. Mendes, Senior Counsel, it's not disputed that to the extent that paragraph 23 is not clear, it may be construed in light of the remainder of the pleading. That is the problem here, because the pleading itself is not clear when construed against the other paragraphs. And I think at that stage, my Lord, can I deal with the way in which it is in fact pleaded in more general terms? My own friend Mr. O'Rourke has already identified that we start at page 6 of the bundle, and particularly paragraphs 3, 4 and 5.
Are we going to be coming back to Woodland? Or are we leaving it?
I suppose, my Lord, what I say about Woodland is this, that in conclusion on Woodland, we say that in each of the 5 steps, the common law steps, if you like, set out by Lord Sumption at paragraph 23, we say that the non-delegable duty, if any, is one that vests in Dr. Gertz.
Well, that analysis was based expressly on the judgments of Lord Green in Gold and Essex, which was a hospital case. Lord Justice Denning in Cassidy, which is another hospital case. And if earlier, Lord Sumption's earlier cited, with approval, Lord Brown Wilkinson in Exon, Bedfordshire, again discussing hospitals.
But those are NHS hospitals, of course, my Lord.
Well, they weren't in Gold, and I'm not sure about. Lord Sumption, paragraph 7, treats a private hospital as the paradigm case, because there's going to be a contractual relationship, and he treats the National Health Service hospital as essentially analogous, because the situation is so close to contract. So if one goes to paragraph, paragraph 7, at the foot of, I'm afraid I can't read them. Well, it's in paragraph 7, at the foot of the page where paragraph 7 begins. I'm afraid I don't have the full number legible on the way my screen is set up.
2947, Lord. Right.
So it says the analogy with public services is often close, especially in the domain of hospital treatment in a national health service, where only the absence of consideration distinguishes them from the private hospital. So then he goes to the origins, and we go back to particularly Dalton and Henry. And then once he gets to deals with employment cases, yes, paragraph 14, a few pages on, begins the discussion of the hospital cases, where we start off with Gold and Essex, a voluntary hospital, as it was described, where it's a liability of the hospital for the negligence of a radiographer. And then Cassidy, where Lord Justice Denning is talking about the hospital's liability for the negligence of a surgeon. And then that's repeated in Rowe in the Minister of Health, and then Lord Brown Wilkinson, paragraph 16 in Bedfordshire, discusses the hospital cases. He doesn't draw any distinction between whether it's a private hospital or a publicly funded hospital. And says it's established that those conducting a hospital are under a direct duty of care to those admitted as patients. They are liable for the negligent acts of a member of hospital staff, whether or not the member of the staff is himself in breach of a separate duty of care owed by him. And Gold, Cassidy and Rowe are treated as the relevant authorities.
Well, yes, but what we say is this, that there is a difference between the situation where a claimant approaches a hospital and says, I need treatment, who is available and who is your surgeon? And we look at these cases where the surgeon is either a direct employee of the hospital, in which case vicarious liability arises, or is an independent subcontractor where there is an argument at law that employment link does not exist and they are not then subject to a vicarious liability. And it is in those circumstances, even when we look at Baroness Hale's commentary and the three schoolgirls in different scenarios, that we need to look at whether it is just and right to impose a non-delegable duty and say to the person who accepts that duty on day one, when they invite them into the school or invite them into the swimming lesson or invite them into the hospital, that they will take care of them, whether that person should then be allowed to delegate to somebody who is not their employee and break that vicarious chain. But we say that in the circumstances of this case, where it had been identified as an issue, as early as the letter of response, that this was Dr. Gertz's patient brought in by Dr. Gertz, it's page 67, once we have identified it at that very early stage, then the burden must surely, in my submission, rest with the claimant to prove those matters as against the hospital. And it is not sufficient simply to say, as the Court of Appeal did, absent evidence, there is a presumption that that is the situation. And, my Lord, that's where we end up with, in my submission, on the Woodland point, that when we get to...
and incidentally, while it's in front of me, in paragraph 15, between G and H, Lord Denning's passage quoted from Cassidy, which Supreme Court goes on to approve, includes that a hospital's duty of care is personal as well as vicarious and therefore non-delegable. So it's an example of a vicarious liability coexisting with a non-delegable duty.
But that's because there is a personal duty as well as the vicarious. And those obviously, in the circumstances of minority view, as cited at that stage of law.
Yes, but it doesn't matter that it's recorded as being a minority view in 1951, when it goes on to be approved in 2000 and whatever this is, 2017, something like that, 2014.
Yes.
A few paragraphs later.
But if one looks over the page, my Lord, at the same quote, the truth is that in case of negligence, the distinction between a contract of service and a contract of services only becomes of importance when it is sought to make the employer liable not for a breach of his own duty of care, but for some collateral act of negligence of those whom he employs. And that, of course, is the difficulty with, we say, the non-delegable duty point, because it has to be an exceptional circumstance, failing which it matters not a jot why one comes to the hospital, whether it's as a result of Dr. Gertz's enquiries in the first instance and that antecedent relationship. Because what we say is that it becomes, if there is to be a non-delegable duty, that is the gateway. Now, it may be, my Lords, that one has to look at the pleadings at this stage.
Could it be said, perhaps, that an antecedent duty on the part of the hospital in the present case arose simply at the stage when the hospital took in the deceased as a patient?
It's not antecedent then.
Agreed to accept him, which they must have done at some stage in the process as a patient, albeit the surgery to be performed by Dr. Goetz and the anaesthetist to perform his role as well. But in the analysis of what must have happened, there must have been a point at which the hospital agreed to accept the deceased for treatment. There must have been some process or step which took place to constitute that relationship. And there perhaps one has an antecedent relationship.
The difficulty, my lord, is that it would then have to, the question then becomes one of whether it displaces the existing antecedent relationship between the patient and Dr. Goetz.
Why can't they both exist?
Well, because the circumstances in which the non-delegable duty is then found to bite, if one looks at Woodland, is where it's just and equitable to do so because of the problem that then arises. If one has, as I've tried to explain in the statement of case, a circumstance where one has an umbrella organisation and everything that happens under that umbrella is the responsibility. For instance, if Dr. Goetz were to say, I want...
Mr. Boyle, if you can wait one moment. We've lost Mr. Mendes, I'm afraid.
I'll hold that thought.
Yes, if we by all means sit down, and we can wait for a minute or two to see if he returns, and if he doesn't, we'll need to see if our recording team can make contact with him.
He has flickered on and off on a couple of occasions this morning, but this is the longest.
Right, thank you.
Sure.
Dave, you're right about the point. It's antecedent. It's not antecedent because of post-date. And I've got paragraph numbers for Pitt Miller.
Nigel, have you?
Yeah.
Thank you.
Put pages.
And see if
pages.
we're able to make contact with Mr. Mendes.
And also where she
Or maybe I... There's nobody in this room, I think, who's able to make contact. Unless we have a... I don't know if you have an email address or something you can...
Yes.
Oh, yes. Yeah, well, it doesn't matter if it beeps. Just,
Are we in short adjournment?
well, effectively.
Oh.
We can go off the bench for, say, 5 minutes, and you can keep us abreast of what's happening.
Oh, yes.
And we can see if you're able to contact Mr. Mendes.
Oh, yes, we won't just start from the net.
Yeah.
Go from here.
Yes. Mr. Boyle, I think we may as well adjourn for a short time. It may take a little time for us to try to sort out this problem with Mr. Mendes. In fact, even to make contact with him, which our usher is going to do. So we'll go off the bench for well, say I hope 5 minutes, but we will see.
But what I was going to suggest was this: it's now 12:42 according to my computer. We at the moment are slated for perhaps 10 minutes after the short adjournment. Yeah. Is it worth taking the short adjournment now and then giving a half-hour block after the short adjournment to finish the submission?
Yes, well, that's a reasonable idea, Mr. Boyle. Thank you. Very well. We'll adjourn now, and we can sit again then at 1:45.
Thank you very much, Rob.
Thank you.